free will.
Voidable and void contracts. A valid contract is a contract that meets the basic requirements of a contract. It meets all five requirements of a South African contract. A voidable contract is a contract where it's been in progress and something went wrong, allowing that contract to end. A breach. Somebody didn't do what they're supposed to do. And a void contract is not a legal contract in terms of South African law. It should never existed, and if they try to hold you to it, they can't.
An interest. Duress arises only if extortive measures are employed or improper demands are made in bad faith. It is never duress to do that which a party has a legal right to do. For this reason, filing or threatening to file a civil lawsuit cannot constitute duress. On the other hand, a threat to file criminal prosecution may be duress even if the threatened party is guilty of the crime. The threat of harm must be imminent, and the threatened party must have no present means of protection. It must cause the threatened person to do what there was no legal obligation to do. Did you know that a contract may be voidable if one of the parties was under duress when the agreement was made? Duress is the mental, physical, or economic coercion of another, causing that party to act contrary to their free will and interest. Duress arises only if extortive measures are employed or improper demands are made in bad faith. It is never duress to do that which a party has a legal right to do. For this reason, filing or threatening to file a civil lawsuit cannot constitute duress. On the other hand, a threat to file criminal prosecution may be duress even if the threatened party is guilty of the crime. The threat of harm must be imminent, and the threatened party must have no present means of protection. It must cause the threatened person to do what there was no legal obligation to do. Did you know?
Right to. Hi, learn with me on Mel Tips. The fourth feature that I'm going over is what makes a contract void. So a void contract can be explained in this way. The classroom example given is, let's say two parties agree to establish a gambling casino in the state of Hawaii or in the state of Utah. So in the eyes of the law, this agreement is illegal because gambling is illegal in both of those states. So that's what would make this contract a void contract. I hope this helps. This is a real simple one. Hi, Audrey.
Here's a tip from a guy.
Valid, voidable, and void contracts. A valid contract is a contract that meets the basic requirements of a contract. It meets all five requirements of a South African contract. A voidable contract is a contract where it's been in progress and something went wrong, allowing that contract to end. A breach. Somebody didn't do what they're supposed to do. And a void contract is not a legal.
That make it a legal and binding document. This is
Assalamualaikum and hi everyone. We are from Group Logical for subject MGM 3352 Business Law. In this video, we will explain to you about valid, voidable, and void contract. Let's chill out and enjoy the video. Before we start, don't forget to give us a
that make it a legal and binding document. This is 6 element for valid contract.
If you need insurance from a change in life, like you left your job, got a husband or wife, if you turn 26 and
Elements of a contract. Before we talk about the elements of a contract, first we have to understand exactly what a contract is. And actually, contract is very simple. It's a promise. When you hear the word contract, think of the word promise. But it's a promise that is legally enforceable under the law. And if there's a breach, then the law will allow a remedy for that breach. So that's what a contract is. It's a legally enforceable promise. Now, we're going to be talking about elements of a contract here. And another introductory word here, is that different writers, different textbooks, different legal sources, commentators will express the elements of a contract in different ways. This is one of the sets of elements of contracts I think is all encompassing, and this is the list of elements that I teach. First of all, first element is going to be capacity. That means that the person making the promise has to be of necessary proper age, usually 18, to be able to lawfully be held to the promise that they make. There's another aspect to capacity, and that is this mental element, that they must be of sound mind. And of course, these two elements relate to natural persons. When we talk about capacity regarding artificial persons, like in which we call entities, like corporations, partnerships, limited liability companies, so forth, and even executors and trustees and guardians and agents in general, those folks enter into contracts too. But we don't worry about or concern ourselves with age or mental capacity there for capacity this capacity element, but rather authority. Do these people that enter into the contract on behalf of the corporation or the partnership, do they have authority? Are they authorized to do that? So that's our first element, capacity. Our second element is offer. In fact, let's just take a quick look at this board. Offer, acceptance, consideration. These three elements are what are generally viewed as the classical elements of a contract. But of course, we're adding in this presentation, we're adding consideration of some other elements as well. So let's take these one by one. In addition to capacity on the previous board, we've got offer, an offer to make a contract. What's an offer? Well, the restatement on contract says that an offer is a manifestation of willingness to enter into a bargain. Manifestation of a willingness to enter into a bargain, so made as to justify the other person that their assent is invited, and that if they assent to the offer, and we're talking about acceptance here, if they assent to the offer, then that concludes the bargain. They got a deal. So that's what an offer is. I want to do a deal with you, and you manifest that in some way. All right, once you have an offer, then our next element that we look for is acceptance of that offer. And that acceptance under classical common law is that it has to be unconditional willingness to be bound by that offer. Unconditional. And in some places, we even see the term mirror image, that whatever the acceptance is, has to be a mirror image of the offer exactly. The offer says, I'll sell you my car for $1,000. The acceptance is, I will buy your car for $1,000. And that's mirror image. So you have to have that acceptance. The next element is consideration. Consideration. Say, once again, what's a contract? It's a promise. Someone's making a promise. So before that person is going to be bound by that promise, there has to be consideration involved. Person gives a promise, but they're receiving something in return for that promise. And that something they're getting in return for the promise is what we call consideration. And once you have that consideration in exchange for the promise given, you're bound, and that's another element of a contract in place. So you basically have an agreement at that point. Now, even though you have that agreement at that point, you still may not have an enforceable contract. And that's what we're looking at here. All these are elements of an enforceable contract. Our next one is you must have a mutual agreement between the people, the parties of this promise, or it could be two promises that are being traded. There has to be a meeting of the mind. They have to be on the same page. They have to have a perfect understanding of what they're talking.
A meeting of the minds and a perfect understanding means you have to know everything about what you're getting ready to sign, and y'all don't. None of these contracts you don't. You don't even know that it's two contracts, so you don't know everything.
About and be in perfect agreement. There's an old English case of one farmer selling what they thought was a sterile cow to another farmer. They made the deal, and then it turns out that the cow was actually pregnant with a calf. And so the question was, well, do we have a contract or not? And the courts ultimately said, no, there was no contract. It wasn't a meeting of the minds because they weren't talking about the same thing. They weren't talking. They weren't involved. They were talking about a sterile cow when, in fact, they were promising back and forth and selling, exchanging between them.
And the same here with cars, houses, whatever. Y'all are not talking about the same asset because you had no clue that the asset ever was paid for.
A very fertile animal. So you have to have a mutual meeting of the mind, mutual agreement. Everybody on the same page.
I don't know why y'all in here. Y'all keep emailing me about
the contract has to be legal in all aspects. First of all, in its purpose or subject matter. If I want to make a contract to buy fireworks, but it's not the fireworks season in my particular jurisdiction, that's an illegal contract for me to take delivery of that, or say alcohol of some kind without having that liquor license, or if I'm in an area that does not allow liquor sales. So it has to be of a proper, has to be legality. Here's a silly one. What about someone who employs a hitman, and the hitman actually turns out to be someone wired by the police, picking up all the wheeling and dealing, and then they make the arrest. Well, why can't the person who wanted the killing done sue the supposed hitman for breach of contract for the promises they made? Of course, that's silly, but it underlines the point. The contract has to be a legal contract. It has to be legal in the way it's procured. You can't procure an otherwise legal contract through bribery, because that in itself is illegal. And the way you carry out the contract has to be carried out in a legal way. Once again, you can't use bribery to carry out a otherwise legal contract. Otherwise, that would void enforcement of the contract. Our last element then is proper form. We're talking about, does the contract have to be in writing, or can it be an oral contract? Well, generally, contracts can be oral. They don't have to be in writing unless there's certain types of contracts. And I've listed a few of these here where a writing is required. Real property transactions must be in writing. A contract that's not going to be performed, it can't be performed within 1 year's time. That contract must be in writing. And another example would be a contract where one person guarantees someone else's debt. They're going to pay someone else's debt for them and be bound by that promise. That has to be in writing. These documents, according to this a law that all states have, it's called the Statute of Frauds. It's an old variation of an old English statute that says certain types of transactions must be in writing, and they must be signed by the person who's making the promise, who's going to be bound by their promise. Okay, so proper form, and that's our last element. So to summarize, here are elements of a contract: capacity, offer, acceptance, consideration, mutual agreement, legality, and proper form. And those are the elements of a contract.
Y'all must be sitting
Okay.
on millions of dollars or just plain clueless.
Some of y'all have contracts where you signed with one company and you ended up with another company. And those are illegal from the gate. If they didn't have a signed contract from you, then they can't collect anything from you. So that's why some of your contracts are so easily to void because they're already, all of them are already voidable. But you just need to display that you know that it's voidable. The only thing that will allow a void contract to survive is if you don't ever ring the alarm. Okay? So that's a little bit about contract law, contract 101. I have 6 contracts I'm working on currently. I usually take 10 and then I cut it off. So I got 6 I'm working on. I'm going to do one free charity contract for somebody who emails me first. And then I'll have room for, I think, 3 more, 2 or 3 more. So yeah, y'all email me